Welcome back to Talk Testimonies. Today, we are diving deep into a really interesting Supreme Court case, Emulex Corp v. Varjabedian.
Absolutely.
And this case is all about whether investors can sue companies for misleading statements during a tender offer.
Right.
Like, even if they weren't intentionally trying to mislead anyone.
Mm-hmm.
So think of it like, a company's trying to buy up a bunch of shares from investors.
Yeah.
And they made some statements that weren't quite right.
Right.
But the question is, did they do it on purpose or was it just a mistake? Carelessness.
Quite sloppy.
Yeah.
Yeah.
And can the investor sue over that?
Right.
So the Supreme Court actually ended up kind of punting on this big question.
They did.
They didn't actually decide it.
Mm-hmm.
So the lower court's ruling stands for now, but it leaves this whole area of law a bit murky.
Yeah, it's definitely a little bit unsettled.
Yeah. So let's unpack the whole story.
Let's do it.
And figure out what was going on in this case.
Oh.
So first off, what's the big deal with this case? Why is it so important?
Well, I think one of the things that makes it so interesting is the way that the central legal question kind of shifted during the case.
Oh, interesting.
Originally everyone was really focused on whether the standard for these types of lawsuits should be negligence or scienter.
Okay, so negligence is basically carelessness, right?
Exactly.
And scienter is like you did it on purpose.
Right. You meant to do it. You had that intent to deceive.
Okay, so that was the first big debate.
Mm-hmm.
But then something else happened, right?
Yeah, then things got a little more complicated. The company being sued, Emulex, raised a bigger question. They basically asked, does the law even allow individuals to sue in these types of cases?
Oh, wow. So they were saying, forget negligence or scienter, maybe there shouldn't be any lawsuit at all.
Right.
Okay.
They were kind of pulling the rug out from under the whole case.
Yeah. So a big twist.
Yeah.
And I bet the Supreme Court justices had a lot to say about that.
Oh, they definitely did. It added a whole new layer to the oral arguments.
So what were some of the key things that the justices focused on during those arguments?
Well, they really dug into the history of these private rights of action in securities law. Where do they come from? Are they explicit in the law?
Right.
Or are they implied?
Okay.
They also looked at similar language in other parts of the securities laws, especially Section 10b and Rule 10b-5.
Oh, yeah. Those are like the bread and butter of securities fraud cases, right?
Exactly. And under those rules, it's generally accepted that individuals have the right to sue, even though the law itself doesn't say that specifically. So the justices were really trying to figure out, okay, if that's the case with those rules, what does it mean for Section 14e, which deals with tender offers?
Right.
And then they also looked at what Congress has done in related areas since Section 14e was passed back in 1968.
Oh, interesting.
Like, have they given any clues in later laws about whether they intended individuals to be able to sue under Section 14 or not?
Okay, so lots of historical context.
Yeah.
And I'm guessing the government also had something to say about this, being, responsible for enforcing these laws.
Oh, absolutely. They definitely weighed in. They argued that, yeah, Section 14e probably covers situations where a company makes misleading statements, even if it's just negligence, meaning carelessness.
Mm-hmm.
But they said that doesn't mean that every investor who feels misled can just go and file a lawsuit.
Right.
They were kind of saying, hey, leave this to the SEC.
Okay, so they were emphasizing the role of the SEC in enforcing this particular law.
Yeah, they were saying, look, the SEC can handle this. They have the expertise.
Okay, so the government is kind of on the fence here, right?
Yeah, sort of. They're saying the law itself might cover negligence, but that doesn't automatically mean everyone can sue over it.
Okay. So what about the investors who actually brought this lawsuit?
Right. They had their own arguments, of course.
What was their main point?
Their big argument was that when Congress wrote Section 14e, they very deliberately used language that was almost identical to Rule 10b-5.
Mm-hmm. That rule we talked about earlier.
Right, exactly. And back in 1968, when Section 14e was passed, everyone pretty much understood that Rule 10b-5 allowed private lawsuits.
Right, even though it didn't explicitly say so.
Exactly. So the investors were saying, look, Congress knew that Rule 10b-5 allowed these lawsuits, and they used basically the same language in Section 14e.
Right.
So they must have meant for individuals to be able to sue under the Section 2.
Okay, so they were really leaning on that connection between Section 14e and this well-established rule.
Yeah, they were saying it's not just a coincidence that the language is so similar.
Right. So we've got one side saying no private right at all, we've got the government sort of in the middle saying maybe negligence is covered, but only the SEC can enforce it.
Yeah.
And then the investors saying, no, we definitely have the right to sue. So with all of that, how did the Supreme Court end up dodging the main question?
Well, here's where things get a little technical. They dismissed the case on procedural grounds, basically saying they shouldn't have taken it in the first place.
Oh, interesting.
Yeah, it's called dismissing the writ of certiorari as improvidently granted.
Okay. So what does that mean for the actual law?
It means that the lower court's ruling, which was in favor of the investors, stays in effect, but only in that particular region of the country, the Ninth Circuit.
Okay.
The Supreme Court didn't actually decide the broader question about whether there's a private right of action under Section 14E nationwide.
Okay, so that's still up in the air.
Yeah, it's kind of a waiting game now to see if another case comes along that might give the Supreme Court a chance to address it more directly.
Okay, so let's dig into the arguments that were actually made.
Okay.
Starting with Emulex, the company being sued, why did they think the Ninth Circuit got it wrong?
Well, initially, their main focus was on the idea that allowing lawsuits for negligent misstatements, just carelessness, was something new and basically unsupported by existing law.
Okay.
But then when they got to the Supreme Court, they kind of shifted gears, and they made a much broader argument. They claimed that Section 14 Aero doesn't allow for any private lawsuits at all.
Oh, wow. So they were going for the whole enchilada.
Yeah, exactly. They were saying it doesn't matter if the company acted negligently or intentionally. Individuals simply can't sue under this law.
Okay, but we talked about how they kind of brought this up late in the game.
Yeah.
How did they try to justify that?
Well, they pointed to a previous case, Central Bank of Denver. And in that case, the Supreme Court actually raised the issue of whether a certain part of the law even allowed for private lawsuits, even though that wasn't the main issue the court was supposed to be deciding.
Oh, interesting.
So Emulex argued that if the Supreme Court could do that, then they should be allowed to raise this issue now too, especially since they had mentioned it in some of their earlier filings.
Okay, so they were saying, look, the Supreme Court has done this before.
Right.
But I bet the justices weren't totally buying it.
Yeah, they were a little skeptical, to say the least.
Yeah.
They pointed out that it wasn't fair to kind of spring this huge argument on everyone so late in the process.
Yeah, I can imagine the other side was probably like, wait, what?
Exactly. But Emulex insisted that they weren't trying to pull a fast one. And they said their argument against any private right was actually related to the negligence versus scienter debate they were having earlier.
Okay, so they were trying to connect those two issues.
They were basically saying that if Section 14E is interpreted to cover simple carelessness, then that's actually a reason why individuals shouldn't be able to sue, not a reason to allow more lawsuits.
So, okay.
And they contrasted this with some older cases where the Supreme Court was more willing to sort of imply a right to sue if it helped carry out the overall purpose of the law. But they said the court has taken a different approach more recently.
Right.
They pointed to the Sandoval case, which said that courts need to focus on the specific words Congress used and what their intent was.
So less reading between the lines these days.
Yeah, exactly.
Yeah.
They were saying the current court is much less willing to just assume there's a right to sue if it's not spelled out pretty clearly.
Okay, and what about the actual words of Section 14E? What was their argument about that?
They argued that the language just doesn't have that rights-creating feel to it.
Right.
You know, there's nothing in there that really suggests Congress wanted to create a path for individuals to sue.
Okay.
They also pointed out that Section 14E is different from another part of the securities laws, Section 14A, which deals with proxy statements. Now, there is an implied right to sue under Section 14A, but Emulex said that's because of a specific Supreme Court case that doesn't really apply here.
Okay.
They were saying that the wording of these two sections is different.
Right.
So just because you can sue under one doesn't mean you can sue under the other.
Okay, so they're getting pretty nitty-gritty with the legal language here.
Yeah, exactly. And their bottom line was that Congress intended for the government, the SEC, to enforce Section 14E, not individuals bringing their own lawsuits.
Okay. Now, I know the investors made a big point about the fact that Section 14E uses very similar language to Rule 10b-5, where, like we said, there is that generally accepted right to sue.
Right.
How did Emulex respond to that?
They argued that the right to sue under Rule 10b-5 actually comes from the broader law that it's based on, Section 10b,
Okay.
not from the rule itself.
Right.
And Section 10b has different wording than Section 14e.
Mm-hmm.
So they were saying just because Congress copied the language for the rule doesn't mean they also copied that implied right to sue that had developed around it.
Okay.
They even went so far as to suggest that the SEC itself might not have the power to sue for simple negligence under Section 14e.
Oh.
They brought up a case called Ernst and Ernst v. Hochfelder to support that.
Mm-hmm.
And lastly, they kind of threw out this warning.
Okay.
So it said that if the court interprets Section 14e to allow lawsuits for negligence, it's going to open the floodgates to frivolous lawsuits.
Oh, so companies would be scared to say anything.
Exactly. They'd be afraid of getting sued over every little mistake.
Right.
And they argued that this would actually hurt investors in the long run.
Okay, so that was Emulex's side of the story. Now let's talk about the government's position.
Right.
They were kind of walking a tightrope here, weren't they?
Yeah, they were definitely trying to thread the needle.
So what was their main argument?
Well, they agreed with the investors that Section 14e probably covers negligent misrepresentations.
Okay, so if a company's careless with the information they provide during a tender offer, the SEC can go after them?
Yeah, that was their position.
Okay.
But they also agreed with Emulex that this doesn't automatically mean every individual investor can sue.
Right, so the government was taking kind of a middle ground.
Exactly.
Saying that the SEC has a role to play, but not necessarily opening the door to a ton of private lawsuits.
Right.
And they had to address that whole issue of the similar language between Section 14e and Rule 10b-5, right?
Yeah, they did.
What did they say about that?
They acknowledged that the language is similar, but they pointed out that a key Supreme Court case that deals with Rule 10b-5, Ernst and Ernst, came after Congress passed Section 14e.
Oh, interesting.
So they argued that when Congress wrote Section 14e, they couldn't have known for sure that this later court case would say that you generally need to show intent to deceive, that scienter, to win a private lawsuit under Rule 10b-5.
Okay, so they were saying the timing of these legal developments matters.
Yeah, exactly.
So if the government didn't think Rule 10b-5 was a perfect comparison, what did they think was a better example?
They pointed to Section 17A, the Securities Act.
Okay.
And there's a Supreme Court case, Aaron v. SEC, that said this section can cover negligent conduct. So they used that to support their argument that the SEC could potentially go after companies for negligence under Section 14e, even if individual investors couldn't.
Okay.
They also talked about how the securities laws have this whole system of different penalties, some harsher than others. And they said this allows for the possibility of punishing negligent behavior without necessarily having to rely on private lawsuits.
Okay, so different tools for different situations.
Right.
And what was their reasoning for why individuals shouldn't have this right to sue under Section 14A?
Well, they emphasize that the right to sue under Rule 10b-5, which is generally accepted, is based on specific language in the broader law, Section 10b.
Right.
Specifically a phrase that says, for the protection of investors.
Okay.
And that phrase isn't in Section 14e. They also brought up a case called Cannon v. University of Chicago,
Okay.
where the court found a right to sue, but they said the language in that case was much more focused on protecting individuals. And finally, they pointed out that other parts of the securities laws use similar language about misrepresentations and omissions, but they haven't been interpreted to give individuals the right to sue.
Okay, so they were building up a whole body of evidence to support their position.
Yeah, they were saying, look, this is how courts have handled similar situations in the past.
And they also had to deal with the fact that lower courts have been allowing these private lawsuits under Section 14e for a long time, right?
Oh, yeah, that was a big part of the debate. They acknowledged this history, but they said their position wasn't really about whether they thought private lawsuits were good or bad.
Okay.
They were more focused on what they thought was the correct interpretation of the law. And they even suggested that the assumption that individuals could sue might have led lower courts to apply the wrong standard of fault.
Interesting.
Like maybe they were too quick to say negligence was enough, when maybe it should have been a higher standard. And they also pointed out that if there's no private right under Section 14e, it kind of creates an inconsistency with Section 14a, which, as we discussed, does have an implied right to sue.
Right, that proxy statement law.
Yeah, but they basically chalk that up to the Supreme Court's more recent, stricter approach to these implied rights.
Okay, so they were saying, look, the court has changed its thinking on this and we need to be consistent.
Exactly. All right, so now let's turn to the investor side of the story. What were their main arguments?
Okay.
Well, they argued that everything really came down to the text of Section 14E, what it says, the context of the law, its purpose, and how it's been understood historically.
Okay, so they were really trying to paint the full picture.
Yeah. And on the issue of the standard of fault, they argued that the plain language of Section 14E supports the idea of negligence being enough.
Okay.
They said you don't need to show intent to deceive.
Right.
They also pointed to how the court has interpreted similar language in other parts of the securities laws, and they said those interpretations support a negligence standard.
Okay, so they were saying, look, this isn't some radical new interpretation. It's consistent with how we understand these laws.
Exactly.
And on the big question, the one the Supreme Court ultimately didn't answer, about whether individuals can even sue under Section 14E, what was their argument?
They argued that this was a case where Congress clearly intended for individuals to have this right to sue, even if they didn't explicitly say so in the law.
Right.
They acknowledged that the court's approach to these implied rights has changed over time.
Like we talked about with Sandoval.
Right, but they said their position was still grounded in the traditional tools that courts use to interpret laws.
Okay.
And they said it's clear from everything, the language, the history, the purpose of the law, that Congress wanted individuals to be able to sue under Section 14E.
Okay, and I know the whole similar language to Rule 10b-5 thing was a key part of their argument.
Oh, absolutely. That was a major point for them.
So what did they say about that?
Well, they emphasized that Congress didn't just accidentally use similar language. They said they basically took the language from Rule 10b-5 and put it right into Section 14E.
Okay.
And they cited a legal principle that says when Congress uses words that already have a well-established legal meaning, it's usually assumed that they meant to carry over that meaning.
Okay.
So they said, since everyone understood that Rule 10b-5 allowed private lawsuits, Congress must have intended the same thing for Section 14E.
Right. So they were saying it's not just a coincidence.
Exactly. They brought up another Supreme Court case that showed that by 1969, pretty much all the lower courts had already said you could sue under Rule 10b-5.
Okay.
So the investor said that when Congress passed Section 14E, just a year earlier, in 1968, they would have known about this. They also brought up those two sections of law, again, Section 14A and 14E.
The proxy statement law and the tender offer law.
Right. And they argued that Congress meant for these two sections to work together. Since there's already a right to sue under 14A for misleading proxy statements, they said it doesn't make sense that Congress would have wanted a different outcome for misleading statements made during a tender offer.
Right. Both situations involve investors making big decisions.
Obviously.
And then there's the fact that lower courts have been recognizing this right to sue under Section 14E for a long time.
Yeah, they definitely hammered that point home.
What did they say about that?
They pointed out that for 50 years, federal courts across the country have consistently recognized the right of individuals to sue under Section 14E.
Wow, 5 decades.
Yeah. They even brought up a Supreme Court case from 1985, Schreiber v. Burlington Northern.
Okay.
And in that case, the Supreme Court basically just assumed this right existed.
Right. They didn't even question it.
Exactly.
Yeah.
So the investor said all of this history, all these court decisions should really carry a lot of weight with the Supreme Court.
Okay.
And they didn't stop there. They also pointed to several times when Congress amended the securities laws after Section 14E was passed.
Oh, interesting.
And they said these amendments show that Congress was aware of this private right to sue and basically approved of it.
Okay, so Congress had chances to change it, but didn't.
Right. For example, they talked about a 1988 amendment that specifically mentioned existing private rights under Section 14E and said this new law wasn't meant to get rid of those rights. And then there's a 1995 law that created a safe harbor for certain types of statements.
Okay.
But the investors pointed out that this safe harbor specifically excludes statements made in connection with tender offers,
Okay.
which they said only makes sense if Congress was assuming that individuals could sue over those types of statements in the first place.
Right, because why would you need a safe harbor if there's no danger of being sued?
Exactly.
Okay, so they really built up a strong case based on the history of the law and how Congress has dealt with it over time.
Yeah, they did their homework.
And they also had a response to that central bank case that Emulex kept bringing up, right?
They did. They pointed out that in central bank, the parties never actually said that they thought a private right of action existed.
Okay.
But in this case, Emulex basically admitted in the lower courts that there is a private right under Section 14E.
Right.
They just argued about the standard of fault.
Mm-hmm.
So the investors said it wasn't fair for Emulex to completely flip their position like that.
Right. So they were calling them out for being inconsistent.
Yeah, basically.
Yeah.
They also addressed that Sandoval case, which emphasized looking at the actual text of the law.
Mm-hmm.
They said that case shouldn't be interpreted so strictly.
Okay.
Like, it doesn't mean you have to find specific magic words to create a private right of action.
Right.
They said it's more about using all the traditional tools of interpretation, including looking at borrowed language that has an established meaning.
Okay.
And they even had a counter-argument to the government's attempt to distinguish the Cannon case.
Right. That case where the court found a right to sue.
Yeah, they pointed out that Section 14E is kind of like a parallel to Section 14A and Rule 10b-5, both of which were generally understood to allow private lawsuits.
Okay, so they were saying, look, there's a pattern here.
Exactly. They were trying to show that their interpretation of Section 14 fit within a broader legal context.
All right, so stepping back from all the legal arguments, what's the big picture here? Why does this case even matter?
Well, I think it really gets at this ongoing debate within the Supreme Court about how much they should be willing to read between the lines, so to speak, when it comes to figuring out whether individuals have a right to sue.
Right, like how much should they be implying these rights if Congress didn't explicitly say so in the law?
Exactly. And this case shows the tension between the court's older approach, which was more open to implying these rights, and the more recent trend, which is much more focused on the actual text of the law.
Right, that shift we talked about.
Yeah. It also highlights how complicated it can be to interpret laws, especially when Congress uses language that's already been interpreted in a different context. And the principle of stare decisis, following precedent, is definitely a factor here too.
Right. All those lower court rulings that have recognized a right to sue under Section 14E.
Exactly. So the court had to consider all of that.
And in the end, they chose not to actually decide the main question.
Right.
What does that mean going forward?
Well, practically speaking, it means that in the Ninth Circuit, individuals can still sue companies for negligent misstatements during tender offers.
Okay.
But in other parts of the country, it's still an open question.
Right. So we could see this issue come up again before the Supreme Court.
Definitely. And I think this case also raises some broader policy questions about how to make sure companies are giving investors accurate information, whether that's through government enforcement actions by the SEC or through these private lawsuits.
Right. So it's not just about legal technicalities. It's about how we protect investors.
Exactly. Now, it's time for the part of the show where we put on our judge robes.
It's 10th chair time.
Yeah, where we get to pretend we're on the Supreme Court and offer our own opinion.
So if we were deciding this case, what would we do?
Well, sitting in the 10th chair, we would voted to dismiss this case.
Oh, interesting.
Yeah. But not because we necessarily agree with Emulex's argument that there's no private right of action at all.
Okay.
Our reasoning is more about the way the case unfolded. Emulex conceded in the lower courts that there is a private right of action.
Right. They just focused on the negligence issue.
Exactly. And then, boom, they get to the Supreme Court and say, actually, we don't think there's any right to sue at all.
Yeah, seems a little sneaky.
Yeah, it's kind of a bait and switch. And while the question of whether there's a private right to sue under Section 14E is important, we don't think this was the right case to decide it.
Okay, so it was more about the process than the substance of the argument.
Exactly. Allowing parties to change their fundamental legal positions so late in the game could create all sorts of problems.
Right. It could encourage strategic maneuvering and make it harder for courts to do their job properly.
Yeah. So we would have dismissed the case and said, hey, if you want to argue about whether there's a private right of action at all, you need to start doing that from the beginning.
Okay. And just to be clear, dismissing the case doesn't mean we're saying the Ninth Circuit was right.
No, it doesn't. It just means we don't think this case was the right vehicle for the Supreme Court to weigh in on this big question.
Right. So the issue is still up for debate.
Absolutely.
Well, today's deep dive into Emulex v. Varjabedian has been a real eye-opener.
It has.
It shows just how complex these securities laws can be,
Mm-hmm.
and how even seemingly small details like the wording of a law or the timing of a court case can have huge implications.
Absolutely.
So, listeners, we encourage you to keep exploring these issues.
Yeah.
Read up on the case, think about the arguments, and let us know what you think.
We'd love to hear your take.
And as always, thanks for joining us on Talk Testimonies.
See you next time.